little bit of introduction, a little bit of idea as to those two major sources of law. I've written on the board behind me a statement regarding constitutional law. Chapter 5, constitutional law is the name of the law that comes from the decisions of the United States Supreme Court when the court uses the Constitution as the benchmark in deciding whether something is constitutional or not. Usually these cases start in a lower federal court, but sometimes they come from state Supreme Court decisions that is appealed to the U.S. Supreme Court. In law school, we take a whole year of constitutional law. When they use the Socratic method, the constitutional law book is at least 4 inches thick, and all they are just cases made by the Supreme Court throughout the years, from when the United States Supreme Court first started making decisions, and those decisions being put into law books. And so it's from each one of those cases that we are supposed to acquire principles, both of law and of how the law has developed over the years. I can't expect you to be able to do that, and neither does the authors or do the authors of your book. However, they do provide enough information to give you that little bit of introduction to this thing called constitutional law, so that when at least you're done with this semester, you'll at least know that it's one of the 4 major sources of law in the United States, and a general idea of how the law from the Constitution has developed. Now, I've underlined the word benchmark in this statement about constitutional law. To emphasize it to you, do you ever hear the word benchmark?
It's kind of compare.
In what context have you heard the word benchmark being used?
In sports?
In contrast.
Even reading a book.
Pardon me?
Even like reading a book.
No.
Like in tests?
What?
In tests?
A benchmark in a test?
Yeah.
Is that what you said?
Yes.
In a text?
Test.
A maybe?
Test.
Okay.
Testing two different things.
Okay. Okay, when the word benchmark here is used, as it relates to the development of constitutional law, the only thing that the justices of the Supreme Court are required to use in making a decision as to whether something is constitutional or not is the Constitution. They don't go to any other famous document. They don't go to they don't go to the Bible, they don't go to the Quran, they don't go to any other famous document. They only go to one source. That is the source of the law. When they make the decision, they look at the law, and the law starts with the Constitution, no place else. Now, depending upon the makeup and of the individual justices, some of them are very conservative in their approach, and they're very fixed. They don't allow anything other than just what the Constitution says. That's called an originalist. And then there are those who are more liberal in their interpretation of the Constitution, and they can kind of broaden what appears to be said in there to come to some kind of a justification to making a decision, all of which have to be based on the benchmark, the Constitution. So, a couple of comments about the Constitution. I've already made them in the past week or two. It's only 4 pages long. It has a preamble, which is nothing more than an introduction, and has 7 articles. Now, I'm giving you some top of my head information here. You're not going to find it in, I will start looking at this handout for you in just a few minutes. But just some information for you, just so that you know what this benchmark really looks like. Have you ever seen it? You ever touched it? You ever seen pictures of it?
The Constitution?
The Constitution. Yeah, what?
I've seen pictures. I think they have like a replica in Washington DC.
Yeah, the Smithsonian.
Yeah.
It's a very important document. It is locked up and safe and protected from all the environmental things, but they do have pictures of it. 4 pages, 4,400 words. Not too many words. Do you know what the kind of thing it's written on?
Parchment?
That's squirrel.
What?
Parchment, isn't it?
Parchment? It's written on cannabis. Before 1920, cannabis was a very legal little weed growing in our country. In fact of the matter is, it was more important than cotton when our colonies developed, and they were growing cannabis, and they were sending it back to England and France and Spain, and making money off of it and whatever else. They used it for clothing, for rope. They also used it for paper. It's called hemp. It didn't even go far back before our country was even established at all. They also, of course, had another use for it, and depending upon the breed of cannabis, it could also be used for an intoxicating substance. In the early 1920s, Randolph Hearst, have you ever heard of Randolph Hearst?
Mm-hmm.
You know, he was the person who built Hearst Castle, that's just north of
California.
San
Same
Luis
thing.
Obispo. He also ran a whole lot of newspapers in the 1920s. He also owned most of all the trees in America, okay? He was the one who coined the word marijuana, referring to those Mexicans who smoked cannabis, putting a fear of the American people into those Mexicans who smoke marijuana. The hemp was the primary product that was used for newspapers until Mr. Hearst decided that he wanted to start using trees. And so he was one of the principal people involved in getting the United States to make cannabis illegal. And for the last 80 years, it has been. Whether it will become more legal, time will tell in a couple of months in a number of states, including California. But to me, it's always kind of interesting to see where the history of this stuff, you know, we just grow up and thinking it's always been that way, and oh yeah, it must be good, it must be right because they've done it for so long. Well, I don't know whether it's good or whether it's right, but it appears that up until the last 80 years ago, it was right for a lot of people for a long time. So anyhow, we come to the law that has developed, called constitutional law. Now let's see what I can destroy for you here as we go through this handout material. I guess what I'll work off of is just this single page for now. No, I don't want to do that. I want to skip over to the next page, and I want to start talking about constitutional law, which is kind of halfway down. Now, that second page on the handout material, there's a couple of blanks A, B that says the U.S. style of law, while its main purpose is the same as every other style of law, is also unique in 2 ways. You don't know. Turn the page. Okay, there you go. Okay, this handout starts off with a single page that says outline week 1. Then it turned the page to another outline. It says Unit 2, Chapter 5, Constitutional Law. Everybody on the same page. You already know what the answer is to those 2 blank lines. The way the American style is unique and different from other countries' laws. Now we come down to constitutional law and administrative agencies, and just some points here for your point of interest. Now, starts off number 1. The American Revolutionary War in 1775. That's not a very good paragraph. So what do I want you to do? Just mark through it.
I don't see it.
I don't either, I don't see it.
We don't have that.
We don't, I don't know where you're looking at.
Why don't you have that?
Well, probably you're
See, I'm
looking
looking
at
at it
different thing.
See, I should have just gone off cut. Which one do you have?
The one that starts us off is every state has its own constitution that was enacted.
Okay. Then I'll find that one. I've got so much information and it ends up being overwhelming. And I don't know where to begin without giving you too much information. Every state has its own constitution that was enacted when the state was first established and joined up to the Union. But the very first constitution was made soon after the Revolutionary War, not way. War. Mine says way. See where it says way? It should be war. For the purposes of establishing a new form of central government that would have the power and the authority to regulate a few matters in the nation's life. Number 2, between the early 1600s and up until the Revolutionary War, not way, like the middle 1700s, the people who lived in America were mainly English citizens. They were governed by the government located in England, and they paid taxes to England. I've already mentioned that as far as I'm concerned, America really was established by the founding of Jamestown in about 1603. Before that time, America was inhabited by a number of different tribes of Indians. That's estimated that there were probably at least 50 million Indians living in America when John Smith and the other people came to Jamestown in 1603.